Well, hello. Sorry, I'm so sorry that I made you guys wait so long. Yeah, I had someone stop by and I was like, "No, oh no. I timed things poorly." And oh, Omar's here? Hey Omar, let me know if you want to join. I can send you the thing and you can let me know if I'm um right or wrong about some of this stuff because some of it I'm not completely sure. Yeah, just let me know. I'll send you the link and I'll send you the my PDF. You know, I always got my notes. So anyway, thank you guys for hanging around and I've I don't think I've ever been this late before. But oh, the big news. You don't know what the big news is. It is about, well, it's a few days old actually, but I was in Greece when it hit. And so I didn't get a chance to talk about it. I wanted to come home and like deep dive it and all that good stuff. But the good news is about the Jen Abel versus Stephanie Jones case. So Stephanie had filed another. Oh, thank you, Gigi. You're worth the wait. You guys are too. I feel so bad to make you guys have to wait. Thank you, Ricardo. Member for 4 months. Hi, Miss Cassidy and lovelies in the chat. I hope your day has been great. Hit us with that good news, Cassidy. So it's not new news. I'm sure you guys have already heard it, but and there was a page 6 article about it that talked about that's why we have Taylor Swift tonight. Um, that with this motion to dismiss, there were some of them that were dismissed, but 2 of them remained. And so those 2 that remain leave. That's what the good news comes from, like what they're going to allow to happen. So the defamation per se, they still have. So the page 6 article talked about how that this is making Blake and Taylor worry because it can open up their communications again. So that's not all though. Like I've noticed like people talking about that part, but that is just a small part of it. And so that's what I want to talk about today because there are some exciting prospects. Now, at the same time, we're talking about the Southern District of New York. And I don't have much faith in decisions that are made there because we are talking about the way that they have been super, super protective of everybody on Blake's team, except for Stephanie Jones. I feel like he doesn't like her, which is hilarious and wonderful. Am I going to the trial? I'm not sure. Some days I think I will, and some days I think I won't. I think it depends on like how crowded it gets. I know the courtrooms are not super huge, and I imagine a lot of press will be there. So if it's a situation where you're lined up outside the door in the morning, then you got to be there at like 5. I probably won't do that. If there's a lot of film crews out there afterwards, yeah, I haven't decided. I haven't decided. Yes, Daphne, that's and Roses too. I think you guys know exactly what I mean. So yeah, I don't, because it's him that is going to be deciding. And even if you appeal, even if Wayfarer appeals things, it's still in the Second Circuit. And I don't trust the Second Circuit either. Like they are super, super protective. So I'm not even kidding. Like when it comes to the New York Times, New York has laws that are way beyond what the Constitution offers. They have more protection for freedom of the press, freedom of speech than literally any other state. And they have not only, I always use the Great Wall built around the New York Times whenever I talk about them, because that's what it's like. It's like every case, they add another layer to that thing. And they have arranged things within the Second Circuit itself to make sure to try to enforce New York law, no matter who is suing them. They want to keep New York as the choice of law so that they can control what happens to them. So Lauren is hiring people to stand in line for her. That is amazing. It's so funny that you can do that now. Like you can hire them through like TaskRabbit and stuff like that. And so Charlie, I kind of avoid cases like that where people are so hot on one side or the other. And I remember I had never heard of the man. Like I am the least politically aware person out there. I didn't know who he was. I heard that an influencer was assassinated when he was speaking. And it was not long after we had gone through that whole subpoena gate thing. And so I was like, I'm like, this is what it's come to. People who I thought he was like me. I thought he was just some YouTuber or something. I had no idea. But I'm like, this is, and we were all like heightened, worried about everything because, like I said, it was subpoena gate was happening. And I'm like, this is what it comes to. Like, our free speech is just destroyed. If you say something someone doesn't like you, they're just going to kill you. I had no idea that he was a controversial figure. And I posted, and in my post, I said, I don't know this man. I don't know like what his stance on anything is, but I'm like, it's just sad that you can be killed for speaking your opinion on things. And then I found out later that he was kind of more I don't know if political is the correct word or just opinionated, or I just found out like the hard way that people are really, really strong about their opinions on him. And so like I got told off. I got a bunch of people unfollowed because they thought that I was like being supportive of him, even though I clearly said I don't even know who this man is. So I just deleted that post, and I'm like, never again. So yeah, yeah, I don't and I wouldn't even know where to begin because I even now like I didn't like deep dive like what he believes or what he spoke on or anything like that. I wouldn't even know where to begin with a case like that. So yeah, I don't like mess. I don't like drama. I don't like squabbles in the chat. So I like our community that we have here. So I'm afraid of like what it would bring if I spoke on a subject like that where it's controversial. So um yeah, but back to this, there are some legal possibilities that got opened up because of this decision. And but they're not sureties. So everything I'm going to say tonight, these are only possibilities. These are not me saying this is what's going to happen. This is what I hope happens. But there's no guarantees. And even if it's something that Wayfarer attempts to do, it's no guarantee that it's going to be successful. So this is like my high hopes of where I hope it goes tonight. But it will be an uphill battle. And I've looked up some United States Supreme Court cases, but as you know, there are situations in the Second Circuit where they have absolutely said, well, here's this United States Supreme Court case, but in the Second Circuit, we do this. Like I've literally seen that on Judge Lyman's order in this case, and it like blew my mind because you don't get to do that. So even though I'm going to present to you some US Supreme Court cases, that doesn't mean that they would necessarily be followed. So this is all just like high hopes if we lived with rainbows and lollipops every day. So take it for that, for what it is. Like this is no promise of what can happen. But this is for sure. One of the things that it does is it reopens discovery. And that's huge. So there are two causes of action that he did leave intact. And I was really disappointed in the ones that he took away. But I do have to say, this time, the way he explained it, it was a little easier to swallow than the last time he granted motions to dismiss, which was to the New York Times and to Ryan. Like that, I still get mad when I think about that. And I've gone over that recently to make my little mock appeal that I'm working on. So, but I think like having just gone through that and then comparing it to this one I found not quite as bad. Hey, Jesse, good to see you. But so it's implied covenant of good faith and fair dealing, which that one's not such a big deal. Like that was like, okay, I'll give you this because you're not going to get very far with that anyway. And he really couldn't deny those because what Stephanie Jones did was absolutely hideous. Yes, this is about Stephanie Jones, Lori. So, but the big one is defamation per se, because when you reopen the discovery, and they get to, because if they have those claims, they get a chance to prove those claims. Now, proving defamation per se is going to open up some really nice, or should. Let me keep correcting myself and not say it that it will, but say it should open up a whole lot of things, because they should have a very broad allowance to prove that case. And now it doesn't just involve Stephanie Jones, but we in the path to sort out what Stephanie Jones did to defame, it crosses a lot of people, because where did the defamation take place? It ultimately took place in the New York Times. And so what it should open up is, in discovery, they can send more subpoenas out, they can depose more people, and it would involve communications that Stephanie Jones may or may not have had with Blake. We know somehow she got that information from Jen Abel's phone to Blake. So they will get, especially through Jennifer Abel, and bless Jennifer Abel for all she's been through. And this is all because of her that this gets to even still exist in the case. But what path did her phone information take to ultimately end up in the New York Times article? Was there communication that Stephanie Jones had with Blake and Ryan? They get to subpoena that to find out all of that. Did it go through Leslie Sloan? We know Leslie Sloan called and spoke to Melissa Nathan on the very day that Stephanie Jones took Jennifer Abel's phone. So they should be able to get to depose that. She's accused in the thing of contacting Sony. It could possibly open that up. And ultimately, communications. Did Stephanie Jones have any communications with the New York Times? So in a perfect world of rainbows and lollipops, they would have absolute access to all of this in order to prove that Stephanie Jones defamed them. So that to me is the happy news. Now, whether or not they get to do it, that's a whole nother story. But that comes to the sham subpoena. So this is the case now. They didn't get to do it because their case was dismissed before they found out where that lawful subpoena kept being mentioned in her amended complaints, and that was mentioned in the New York Times article. They never got to find that out until after the motion to dismiss. But now, this is where Vanzan finally gets to rear its ugly head. So that's what I'm excited about. So that's why I say there's good news, because it does open up some possibilities that have been closed off to Wayfarer until now. What else would it be? Like I said, that transfer of Jennifer Abel's phone's contents, where all did that go? Anybody who touched it or had a part of it, or who had physical custody of it, they're in the line here. So this could possibly, if everything goes as it should, open up a lot of new things for Wayfarer. So that's what I'm psyched about. I'm going to stay hopeful until I can't be hopeful anymore. But if you're have to prove things like motive, if you have to prove something really difficult to prove like malice, you get a really wide berth for what you need to prove that. I'm sorry. I have to say should. I have to keep saying should. Oh, you're okay, Christina. Welcome. Yeah. So anyway, so with the implied covenant claims, it also involves things like motive, intent, that internal decision making. How did it end up going where it went? Whether Stephanie acted to undermine Wayfarer. So you're talking about intentions and motives. Those are difficult to prove. And so you should get a lot of leeway in what you're allowed to subpoena. So yeah, could be good if yeah, I can't stop reading the chat. You can always tell too because I get distracted right away, forget what I'm saying. And then the last one, whether Jones Works deprived Wayfarer of the fruits of the contract. She had a contract with them. Now, he did destroy some of the other claims because he said, for example, yes, they were contracted with her, but they weren't contracted with Stephanie Jones as an individual. They were contracted with Jones Works. So, like their claims that she wasn't really there for them doesn't really matter because they were represented by Jennifer Abel. And they admit that they were happily represented by Jennifer Abel. So I can understand why he said that stuff it, Omar. Why that one was done away with, but it's not completely gone because we still have these other two. I'm gonna I type all these extensive notes and then sometimes I forget about them. And then afterwards I'm like, oh, I forgot to say that. So defamation per se. Now this one's a big one too, because you have that actual malice in there. That is almost impossible. And so should be allowed, like I said, a lot of leeway in what you have to subpoena to prove that. There's also things like falsity, publication, damages. It is notoriously broad. And Jennifer Abel and Wayfarer, they have to prove these things. So that could work out very, very well because of this. What they should be able to seek are emails and text messages between all of those people, Jesse. Not moist mealy apple. You guys are so bad. So from all of those people that we just saw, these are the things that they can subpoena or should be able to subpoena from them. Emails and texts between all of those people, Slack or Teams messages, PR strategy documents, communications with Blake's team, who leaked it to Blake, who got it ultimately to the New York Times, internal discussions about Wayfarer, internal discussions about the New York Times. Now, what happened with the New York Times is not only did they get their case against them dismissed, but Judge Lyman also stayed their discovery. So they never had to turn over one single piece of anything. So even if he does not allow them or allow Wayfarer to directly subpoena them as third parties, they still should be able to subpoena the other people for communications that they had with the New York Times. That remains to be seen how much he's going to step up and protect them. But these are all possibilities. Yeah, you're right, Christina, that this case is going to be the juicy one. Once he stripped Wayfarer of their chance to pursue the case, this through Jen Abel. And that was the one thing, like she went through so much and it's because of what she went through, that any of this still remains. So at least it wasn't for nothing. I mean, all of us would prefer that she never had to go through that, but at least it wasn't in vain. Like she can get something out of it. Um exactly, Julianne. If he allowed us to be subpoenaed, he shouldn't protect the New York Times. Exactly, because they were fully involved in the whole thing. Fully involved in the whole thing. So here are the things that like I said, when you have to prove actual malice, you do get entitled to probe a lot of things. Now, what does it take to prove these things? If you think about it, it takes a lot. Now, when he granted to the other parties motions to dismiss, it limited what Wayfarer was allowed to request at that time. But with that wide open, it reopened stuff that they were deprived of being able to get. So, sorry, I'm making sure I'm on the right page here. With these new chances to get this information, it becomes new information, which you call in legal terms newly discovered evidence. That is the key to what I'm talking about today. Because when there is newly discovered evidence, that is a very powerful thing. So when things have been like in an appeal, like we went through the Murdaugh appeal, they called like what they discovered, Becky Hill, the clerk of court, what she had done, they called that newly discovered evidence, and they got an extra shot at things because of that. Newly discovered evidence is very, very powerful. So in this case, it happens to fall on the right side. So what happened? What's newly discovered? The Vanzan subpoena. So that is the powerful door that can hopefully be opened to them and can change the course of everything. Sorry, I'm reading to make sure. But this new thing, like this is Blake's nightmare. This is Blake's attorney's nightmare that this is happening right now. I wonder if they've cautioned her about just how bad this can end up being. But they have got to be shaken in their boots right now. And the New York Times has got to be pretty worried too. They've got their, and it might be why they wanted to get their whole anti-slap thing going in the New York State court, because they were bracing for this. But they all must be very, very concerned about where this can all go from here. What else can, let me see. This is kind of repetitive. But with the New York Times, here's another thing that could possibly be looked into. How and when the information was given to them. That's a big question. Now, Judge Lyman did back bends and back flips, and I mean, he did the whole Olympic gymnastic routine to free them from the rest. And that involved coming up with cases that were unpublished instead of established cases, just to try to stretch that judicial proceeding that allows the fair report privilege. But if it comes out that the New York Times was given information even as far as October, that's a bigger deal than he made it seem. And if somehow they were given information, say, for example, Blake went to someone that she knows, or one of Blake's representatives went to someone that they know at the New York Times and said, look, she's got this lady's phone contents and look what they were doing. This is a story. And the New York Times said, oh, that's really interesting, but we've got to legitimize this somehow. That could be crazy. That's one possibility that could come up. That's one thing they get to research now that they never got to research before. And if that comes out, that's going to be even huger. As I said before, her communications with Sony, her communications with Leslie, with Blake, and then also, and I've wandered so far into these other people because they make me so excited, that I forget, like, this is gonna just destroy Stephanie herself. This is gonna go into her conduct during the PR crisis. So it's gonna be things like, who did she talk to set up that day when Jennifer Abel comes in, and she was ready with security, and she was ready with her, director, and she was ready with, lawyers sitting there with stuff for Jen Abel to sign. Like, that stuff was pre-planned. So that kind of conduct, that's gonna get looked into. So this is really, really bad for Stephanie Jones. And I don't know if you guys saw the news that, she just lost Tom Brady. Like, he was her last big client that was often talked about as being, like, one of the really, really big ones that she represented. She lost that. I don't know if that was today or yesterday when that came out, but she is not having the best, the best year. But, and by her this was all her spite. This was her anger at Jennifer Abel. This was her anger at Wayfarer, and this was her wanting to hurt those people. That's where all of this came from. So Blake had already done the damage that she could do with the movie. But if it had ended there, that kind of would have been that. But it was Stephanie Jones and this little evil revenge that she sought on Jennifer Abel for moving on with her life, like she had every right to do. I mean, Stephanie Jones had poached her from someone else, and I'm sure for her that was fine. But when she wanted to leave and make her own company, it was the end of the world. And then when Wayfarer wanted to follow Jennifer Abel, like, this is all her nasty, angry, evil revenge. And now look at what she's done to herself. It's so funny to me because these people set out to destroy Wayfarer, and I think they thought it was going to be easy. And in the end, it's actually them that have gotten the biggest blows dealt. And it's a beautiful thing to witness. All right. So what are they going to get to do? They're going to get to serve new RFPs, requests for production, serve new interrogatories. So, and you better believe they are ready now with some questions that they did not have at their disposal way back when this first started, because now they've been able to learn a whole lot more about what went on. So their questions can be so much better than what they had to work with before. And even at the time they started their depositions in the original case, they still didn't know a lot of stuff that they know now. They get to do that all over again with all of this new information. And we've seen how beautiful it is because of the great unsealing. Yes, it can. This is what's opening Van Sham. This is it, and this is why I'm so thrilled, because I have been waiting for this moment, and I thought it wouldn't come. I really thought it wouldn't come in this case. I thought it was going to be something that they were going to have to either appeal, or that at the end of this case, that if the statute of limitations hadn't expired, that maybe they could do something in a California court later. But it looks like, thank goodness, this can be, this is the thing. Yes, exactly, Lisa. Third party discovery. This is the, and your smile matches it. Like, that's how I feel right now. It's no champagne corks popping in effing Sham Palace tonight. Exactly. Exactly. Yes, he will have less spousal privilege because he'll have communications, I'm sure, with these people. Yeah, because this is about Stephanie Jones, his communication with Stephanie Jones. He can't claim any privilege with that. So, oh, Gelth, I'm sorry to hear that. Are you sick? Well, I don't want to pry, but I'll just say I'm sorry to hear that, and I hope you're okay. Yes, yes, and I agree, Daphne. Daphne says, Omar told us a long time ago that he believed Justin Baldoni and team had some cards up their sleeves and the better case, simply based on how he saw them lawyering. Yep. And when people were losing their faith in Brian Friedman a long time ago, I said, he's being smart. He's being quiet. Like, don't expect a good attorney to be out here making a lot of noise. They're not going to give themselves away. They're not going to give their case away so that they can do this, that they can sneak up with something like this and bam. I cannot wait. Yes, Proxima. Yes, I just said that a moment ago that Tom Brady left. So yeah, it's payback time for all of this good stuff. The other thing is like resisting these things. Stephanie's not going to have an easy time to try to resist any of this. She's been fighting for a very long time. Like, this was the end. Like, he's like, no, this is, you got to do this. You did that. There's proof you did it now. And these claims still survive against you. So she's not going to be able to, she's going to try. They are going to fight for their lives for this, just like Blake did. Like all the awful stuff we just went through with discovery in her case. It's going to be ugly, but she's not going to have the leg to stand on to try to deny some of these things. And the issues they're fact heavy. They're stuff that has to go before a jury. The conduct spans multiple people. It spans multiple months. The chance of this getting done away with on like an MJOP, if it didn't survive the motion to dismiss, it's not going to survive that. And to survive a motion for summary judgment after they get all of this new discovery that they're going to be able to get, I don't see how in the world it can survive a motion for summary judgment. So what goes on from here? Now, if the New York Times, if it comes out in this new discovery that they get to get, that they knowingly relied on a sham subpoena, it opens things up for them concerning them again. And that's the biggest news to me, because you guys know this New York Times thing has bothered me from the very, very beginning. Because if they relied on a sham subpoena, if by chance Blake came to them with the story and they said, oh, you've got to legitimize this somehow, that's bad. If Blake presented this sham subpoena to them and they saw it or should have seen it, and they relied on that for these thousands of pages of text and emails, that does not look good for them. If they knowingly relied on a sham subpoena to publish an article while aware or deliberately avoiding the truth that the subpoena was illegitimate, if they did these things, they now face some serious exposure under defamation law. Can they be turned around and sued for defamation? Probably not. We're going to talk about, though, why that doesn't mean they're off scot-free, specifically on the element of actual malice, because these kinds of things could prove actual malice. There is a possibility of reopening that case. It is very, very slim. I don't know that I would bother to try to reopen this in New York. But that's not the only option for Wayfarer. So what do they need to know in order to try to start to prove that the New York Times had reckless disregard, had actual malice? They need to know how the New York Times obtained the documents. So that should allow them to get a pretty good amount of discovery about communications with the New York Times. They need to know whether or not the New York Times knew the subpoena was fake. But here's the thing, and we're going to talk about this more later. Any person who knows anything about the law can look at that subpoena and the lawsuit that it was attached to and absolutely know without a single doubt in their mind that something was wrong there, that that was not a legitimate lawsuit and therefore could not be a legitimate subpoena. And if the New York Times relied on and reported that these things were obtained through a subpoena, they are legitimizing their story. That brings them huge responsibility. And if they did that, either disregarding that subpoena, the questionableness of that subpoena, or knowing the questionableness of that subpoena, that is huge. So Wayfarer needs to know whether they had reason to doubt the legitimacy of the materials. But that's almost a joke because how could you see that lawsuit, that subpoena? You know that Blake is saying she's suing for sexual harassment, and then you see Vanzan suing Doe's when she has all these details of exactly who she's suing and for what. It should be Blake or her LLC that she signed to do the movie with. And the defendant should be the movie, not this Vanzan versus Doe's. There is no way that the legal department at the New York Times can say that they had no reason to doubt the legitimacy of it. I mean, a judge should laugh at them should they try to pull that off. What else do they need to know? Whether the New York Times coordinated with the Jones parties or with Lively's team. We know they coordinated with Lively's team. Did they coordinate with Stephanie Jones too? And whether, and this one I can hardly say with a straight face because it's just so ludicrous, whether or not the New York Times ignored red flags. There are so many red flags, and they have a very big and very strong legal team. They ignored red flags. I mean, if they're that dumb that they couldn't see something was wrong with a Vanzan lawsuit with contract claims and then that ridiculous subpoena, and we're going to get through just how ridiculous that subpoena was. What? Jesse Ryan was just advertising on my on my YouTube channel. Do you know what's funny is like the advertisers on YouTube, they select the accounts they want to advertise on. Like they know who they're advertising on. I think he does that just to taunt us. Because I was watching Popcorn Planet the other day and he popped up on it too. Thank you, Ricardo. The judge should get mad. He should. He really should. But if their legal team is that inept that they didn't see through that, like they all need fired. But there's no way they didn't. I'm telling you right now, I can say that most of what I'm saying today, I cannot say with 100% certainty, but I can tell you of all the things I'm telling you tonight, with that one, I can say that with an absolute certainty. That one look at that lawsuit under Vanzan to Doe's that doesn't match the subpoena, that was never assigned a judge, that was sent directly to Stephanie Jones. There is no way a lawyer, a first-year law student wouldn't know something's wrong there. Okay, now let's talk about malice, because malice is something that they have to prove, and it's something that is notoriously nearly impossible to prove. So what is it? It is knowledge of falsity. And it's kind of hard to prove because it's like getting into someone's brain. Like, how do you prove that someone knew something was false? So that's not the only option. The other option is reckless disregard for the truth, which means should have known. So would a person in their shoes, should they have known something? That's what you have to prove. Unfortunately, there's been like case after case after case that made that standard more and more difficult because, as you know, previous binding authority or case law will determine how strict that gets applied in your particular area. So if it's federal court, it's in your circuit. If it's state court, it's in your state. So that's where things get a little messy, because in New York, they've made that like an almost unsurmountable wall to climb. So what is reckless disregard from a legal standpoint? It is purposefully avoiding the truth. It is something like getting a subpoena that doesn't match the lawsuit that it's supposed to go with. It is something like, this lawsuit is between Blake and the movie she worked for, or the production company that she worked for sexual harassment. But you see a lawsuit that says Vanzan versus Doe's 1 to 10. And you see that it's never been assigned a judge. You see that nobody was notified that the subpoena was coming, and that the subpoena has nothing to do with the causes of action in the lawsuit. That is purposefully avoiding the truth. Ignoring obvious signs that information is unreliable. What I just said. Relying on sources with motives to lie. Now, this is interesting. We're going to come back to that in a little bit. Publishing despite serious doubts. So, was the story just too good to pass up? You wanted to get that story out, so you ignored all of these things that you should have seen? That's actual malice. I think in this case, with what we already know, you could come up with that. But we're going to get even more with this discovery being opened up. Now, if the New York Times saw a subpoena that looked irregular, reckless disregard, if they still published anyway. If they knew the lawsuit was a sham and still published anyway, reckless disregard, actual malice. If they received documents through a process that made no legal sense and published anyway, reckless disregard, and ultimately actual malice. So you guys see why I'm so excited. I'm like literally getting so excited. And this is the Supreme Court standard has said this. They've approved this. So Judge Lyman and the Second Circuit is going to have to say, oh, we're going to do our own thing. Because if they follow what the Supreme Court has said, this will meet that criteria. So a little bit more, because I want it to be very, very thorough. If they relied on a subpoena that came from a lawsuit that was filed solely to generate it, how do we know Vanzan was filed solely to generate that subpoena? Because it was opened within a couple of days to Stephanie Jones, who immediately started sending the stuff to Blake. And then that very month, so it was filed September 27th. The subpoena was issued October the 2nd. And in October are the first dates that came up in the metadata of what was given to the New York Times. Do you guys remember that? And even Judge Lyman acknowledged that in a footnote in the order where he dismissed the case. So he knows that there is proof that the New York Times had stuff in October when that subpoena was served, just days after that lawsuit was filed. What else happened? That lawsuit was yanked the day before the CRD complaint was filed. It was just withdrawn. And that was just 2 days before the New York Times article came out. And that is the only thing that lawsuit did. We have the full docket. We can go look at it right now. We have the complaint that was filed, because you have to do that. They never asked for a judge to be assigned. They sent out that subpoena, and then they withdrew the case. And that is the only thing they ever did with that lawsuit. Does that look like a lawsuit that was filed solely to generate that subpoena? I don't think anyone would question that. If they can find that it was not properly served, you are supposed to notify the people involved. And was there notification? We don't know. We know that nobody in Wayfarer was notified, even though it was Jen Abel's phone contents that they were getting. And you can argue, yeah, it was a company phone, but that phone number and some of those contents on that phone were completely personal that were accessed. So she should have been notified. And we know a Doe lawsuit, you have to go. I showed you there was a case that went through the very court that Vanzan was filed in. I showed you that just last summer. That case went through, and we saw that that man had to do all kinds of things to prove to that judge. And there was a hearing before that judge because that's what's supposed to happen. He had to have documents, he had to have affidavits, he had to prove that he had done his absolute best to try to identify those does. And then he was finally granted a narrow scope by that court. That is the way it's supposed to go. None of that exists in this case. So, was that issued correctly? No. Was it created by the Jones and Lively's teams? Was it this conspiracy between Stephanie Jones and Blake Lively? That's what it looks like. Stephanie Jones is the only one who got subpoenaed, and she was subpoenaed within a couple of days of a Doe lawsuit where you're saying, we have to identify these people. We don't know who they are. How did you identify Stephanie Jones that quickly? You know, what does it look like? Then the New York Times representation that the documents were obtained via subpoena. These are things that they said in their article and things that they said in the accompanying video. And when they said that to legitimize their story and partially in the hopes of protecting themselves. Thank you, Justin Smotherman. Would it have been better to have waited to sue the New York Times? Well, not really later. I would have never brought it to New York. I would have left it in California. I would have fought with my entire life to keep it in California. I would never sue the New York Times in New York. But what's supposed to happen when you file a lawsuit is you're supposed to be allowed to get discovery to prove your case. But New York law is set up to where you get dismissed before you ever get a chance to prove your case. It's jacked up. Something stinks in the Second Circuit. You don't get a chance to prove your case. You don't get due process. You don't get the right to take someone to court for defamation if they're, especially the New York Times in New York. That's what they've done. And thank you, Justin, for the $5. So, if all of these things are true, then them saying this in their article that it was obtained via subpoena, that's a misleading statement that they've made. It is also potentially defamatory if it bolstered the credibility of false allegations. So if Blake's her allegations were false, which we all believe they were, and they said all of this based on something that they knew was a sham, this is really bad for them. This might be the case that finally breaks through this wall. Now, if the discovery from the other parties opens New York Times up, it should allow Wayfarer to actually subpoena them. Whether or not Lyman would let that happen, I don't know. But it would include things like the reporter, Megan. It could open her, what about your notes? What are your notes on this case? Who contacted you? Who emailed you? Who called you? Who texted you? Did you talk to Stephanie? Did you talk to Blake? What did your legal department say about this sham subpoena? And that would include the metadata that shows when and how the documents were received. If she received something before Vanzan, the Vanzan thing is bad enough. But if she received stuff before, that's going to be really, 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 really bad. And See what her communications were. Was she trying to justify things in communications with them? This is why I'm so excited. I really, really am so excited. So if it's found they were involved, if they go through all that discovery and they can prove what we think happened, actual malice becomes provable, defamation liability becomes real, punitive damages become available, reporter's privilege may collapse, and they can face deep discovery into their reporting process. These are my wildest dreams. That's what I want to get to, Ricardo. That's why I'm so hopeful and excited about this. Could new evidence here be found that could allow Wayfarer to try to sue again, despite Lapdog's ruling, and if statute of limitations passes during the course of all of this? So if statute of limitations passes, we're in trouble. But yes, and this is, look at this case. Saint Amant versus Thompson. And like I said, when it comes to the Second Circuit or the Southern District of New York, I always try to find the highest level cases I can find. So US Supreme Court all the way when it comes to them, because they like to do their own thing, and their Second Circuit law is just personalized to their preferences. Recklessness may be found where there are obvious reasons to doubt the veracity of the informant. Who was the informant in this case? Was it Blake? Was it Stephanie? Was it Leslie? Or the accuracy of his reports? Did they present a sham lawsuit to you? You would have had obvious reasons to doubt it. Is there a chance they're selling you their side of things? This isn't a reporter that went to the courthouse or looked up the courthouse and saw a juicy case and said, I want to report on this. This is a reporter who was approached by someone who had a story to tell with a very specific side of the story. That's dangerous grounds. Because when it's a party to the case, naturally, they're going to tell their side. You should always take that with caution. So says the Supreme Court. Now, part of that would be if they failed to investigate appropriately. Now, I do have to say, in the Second Circuit, they have pretty much obliterated that. Even though it comes straight down from the U.S. Supreme Court, they've had rulings in the Second Circuit to obliterate that. They're like, well, as long as they're reporting on a judicial proceeding and they reported what the case says, they're still protected. I mean, it gets ridiculous. I've been deep diving it for a couple of weeks now. Another case, a little more recent than that one. That one was kind of old. Hart Hanks Communications, Inc. versus Connaughton. The purposeful avoidance of the truth is in a different category from mere negligence. Thank you. And is sufficient to support a finding of actual malice. So there's like, oh, I missed that. I wasn't quite diligent enough. That got by me. That happens to all of us. So I understand laws that protect reporters from that. If they truly did their best and just from human imperfection missed something, like you would hate to see them punished severely for something like that. But purposeful avoidance of the truth is a whole nother thing. So if you look at this and you've got all of these red flags that we just talked about, and you're like, but this is a really good story and I want to tell this story, and so you just avoid it. I mean, that's like premeditation. You know exactly what you're doing. The newspaper, this is also quoting from that case, the newspaper deliberately chose not to acquire knowledge of facts that might confirm the probable falsity of the charges. And so That's what this US Supreme Court said. These are the measures that they are bound by because this is the US Supreme Court, gal. Send me moist chicken butt love because now in ER. Aw, sending you the moistest chicken butt love. I hope you're okay. Keep us updated. Okay. Sorry, guys. And then we come to the case itself, the very case that changed everything about libel. This case basically did away with libel because before this case, this protection had to do with government officials because the whole reason for this protection in the first place for the press was not just so they could run willy-nilly and say whatever they wanted. This was about government officials. And it's because the government in a democracy is supposed to be transparent. And so these government officials, they choose this life knowing that risk. The public in general has a right to criticize, has a right to look into what these government officials are doing. That's what the original freedom of the press was all about. It was not what it is today. Libel was a very real cause of action. It was even criminal. So it started to get stretched, but nothing stretched it quite like this case. And later, then it was no longer just applied to public officials. It started to be applied to public figures. And then the definition of public figure has been stretched to the absolute limit today. It's kind of sickening when you think about what the fair report privilege was initially for compared to what it has become. It just is so very wrong to me. But this was the case that kind of started it all. But even looking at this case still had limits. So it said the constitutional guarantees require a federal rule that prohibits a public official from recovering damages. And notice it said public official. This was government people. From recovering damages for a defamatory falsehood relating to his official conduct. That's what it was protected originally. His official conduct as a government official. And then they added later a clause that said, well, because they are supposed to be exemplary citizens, like we have a high expectation, if you're going to stand in this position, you should have your private life should be exemplary too. So it extended to say, yes, if it affects their reputation as a public official, that's covered as well. So you see, even back when this landmark case was put into effect, this is what it was talking about. It wasn't talking about what it is today. So his official conduct, unless he proves that the statement was made with actual malice, that is, and here's how they defined it, with knowledge that it was false or with reckless disregard of whether it was false or not. So that was the standard. And then it's just kind of grown into a 10-headed beast in New York. All right, keeping that in mind. So we've gone through those US Supreme Court cases and what they have said, what they have decided, what the limitations are, what it takes to prove. Now let's talk about this argument that I came up with. I told you guys I'm working on a mock appeal. And this is something I came up with in that mock appeal that I was saving for when I finally get that to you, but it applies so much today. And I'm really proud that I thought of this. Why, if there was a valid lawsuit properly filed in a New York State court, did Blake and the New York Times choose to rely on a private administrative complaint as the means for their fair report privilege? What do I mean by that? There is absolute privilege when you're speaking on something that's filed publicly in court. That's why I can get on here and talk about what I'm talking about, because this case is in a public court. Everything I talk about is publicly filed or public information that I have found somewhere. That is the kind of thing that is completely privileged. So why did the New York Times not say, hey, there was a valid lawsuit? That's our unquestionable privilege. Why instead are they holding on with their fingertips and the skin of their teeth to this CRD complaint that is not a judicial proceeding, that is not a public thing, that is an administrative thing that Blake filed in California? And because of what she did, it didn't become an investigation. There was no proceeding whatsoever going on with that CRD complaint when this Times thing came out, because she said, I don't want you to investigate it. I want a right to sue letter, which means there was nothing but an administrative filing in California that was private, not public. That's all there was. And they are grasping at that administrative complaint and calling it a judicial proceeding. And Judge Lyman doing everything he can possibly do to legitimize the fact that the New York Times had articles or had pictures and text messages months before that to try to he's posting unpublished cases to try to say that it's, oh no, this CRD complaint it's enough to cover privilege, when supposedly there's a legitimate case filed in New York State court that would unquestionably protect them. But they never used it. They never said, hey, we're protected because Vanzan is here in this state court. Never once did they use that as a defense. What does that tell you? That would have given them absolute privilege. What does that tell you? They knew something was wrong with Vanzan. They didn't want that to be their cover. They didn't want that to come out. You know, a lot of times in newspapers, when they talk about something that's filed, oh, the subpoena from this lawsuit, what do? They put a link to the docket or a link to the PDF file so you can look it up to back themselves up. It's like everything I do on here. I always like to have the cases here or the document up here for you to look at. So like, you don't have to say, oh, Cassidy said that. You can like see where I got the information from. That's what they like to do just to protect themselves. Nowhere in that news article, nowhere on that video did they tell anybody about this case that was in the New York State court. They did not rely on it. And that is huge. That the only reason they wouldn't do that is that they were trying to keep that quiet. Why were they trying to keep that quiet? Because they knew something was wrong with it. Do you guys know what I'm saying? Like, this is huge. Why didn't you use it? All right. So another thing they can find is what did the New York Times actually receive? So if the New York Times is going to tell the world, oh, this stuff that we obtained, they say we obtained it. They say we reviewed it. And then she testifies about, oh, these texts show this and this, or it proves this and this. We're going to tell you what really happened with all of this certainty. And she backs it all up, legitimizes it by saying, oh, a subpoena. Did she actually receive that subpoena? Did she know it was obviously not correct? The lawsuit was obviously a sham. Did they ever bother to look it up? Like I've said a million times, if someone tells me something about a case, says, oh, I got this case, and gives me all the juicy details of it, you think I'm just going to go live and start telling you about it? Absolutely not. The first thing I'm going to do is go to the courthouse where this alleged lawsuit lies, and I'm going to download it for myself, and I'm going to read every single document and know that what I report is going to be accurate. That is what they're supposed to be doing. We should not expect more from people on YouTube than the New York Times. It's crazy to think that they didn't look into this lawsuit and this subpoena. So Wayfarer gets to say, hey, you talked about a subpoena in your article. Where is it? Did you see it? I want to see when you got it. I want to see what you said to people about it. I want to see what you told your legal team about it. I want to see how you decided that it was an adequate subpoena. But these claims that they made in the article about the subpoena, this is going to be really bad for them. Wayfarer gets to see, what did you do to verify the legitimacy of this? Is it in your Google searches? Did you go on LexisNexis? What did you do? Did you run down to the courthouse? Did you access the courthouse? Like, where's the metadata? Where's the proof of what you did to verify the legitimacy of this? And here's the bottom line. They published it anyway. What does that mean? If all of this stuff gets proven and turns out to be what I think it was, what you guys all think it was, that's fraud. Because they sat there and said, obtained by a subpoena. That's now fraud. And they've fought in this court. They have told this court that they got this stuff through a subpoena. They have fought that they are under this privilege. That is fraud on the court if it turns out that they knew all along something was wrong. And I don't see any way on this earth they didn't know. And guess what, chicken butt? It can reopen a dismissed case. That's the best news. So Ricardo was a little ahead of me. It can void a judgment. There's a 60B motion that they can say, hey, we got newly discovered evidence that we didn't have access to when you dismissed our case. We need you to void that because there's been some fraud here. It can expose the New York Times to sanctions. Because, like I said, they've argued extensively in this court to Judge Lyman that they were operating under the fair report privilege. They specifically talked about the subpoena, and they were hiding what lawsuit the subpoena came from. They didn't say, we're protected because of this lawsuit. Here's the lawsuit that protects us. They didn't want the court to know what lawsuit they were claiming protected them. They didn't even claim it. If they knew that that was all a sham, it's going to be really bad. So here's another U.S. Supreme Court case. It's Herbert versus Lando. Now, what does this one say? Let me check my notes, make sure I don't miss something. Now, as much as New York is going to want to protect the New York Times, this is another U.S. Supreme Court case. It is binding authority. It's not been overturned. The scope has not become more narrow over time, like sometimes happens. This is still a very important, very big case that they're bound by. And it speaks on this kind of situation. We hold that the First Amendment does not forbid inquiry into what? The editorial processes of the press. This gets deep now. This isn't just who contacted you, who emailed you. When did you find out? They get to get into the nitty-gritty of the editorial processes. The First Amendment does not shield the editorial process from civil discovery. Wide open. I don't care what you say, Second Circuit. I don't care what you say, Southern District of New York. This is the Supreme Court. They rejected the idea that there's some kind of editorial privilege that would stop them from inquiring into a journalist's state of mind if this kind of stuff gets discovered. Because if you got to prove malice, that's what you got to get into. You got to get into their state of mind. How do you do that? You have to have all of this access. So says the US Supreme Court. Actual malice is a horrible standard, horrible standard to prove. And so it requires all of this. It also says to erect an absolute privilege would substantially enhance the burden of proving actual malice and might well make it impossible to prove. So that's why you can't have absolute privilege, even though New York has absolute privilege against what the US Supreme Court says. Proof of actual malice calls a defendant's state of mind into question. So if they try to stop them from getting into this, it can go all the way up to the US Supreme Court. They could take it that far because it's a constitutional issue at that point. All right, so what does this case now open up? Now, like I said, this isn't just their communications between Stephanie Jones or Blake Lively. This is the reporter's notes. This is drafts that were made by the reporter. This is internal New York Times emails. This is editorial discussions that they had. This is their discussions about the subpoena. This is emails between the reporters and the parties, both Jones Works and Lively. This is stuff between the reporters and the legal department, and all references to the subpoena. This opens them up to a lot. We know, like I said a moment ago, that some of these things were sent to them as early as October. There's probably a lot of interesting conversations that happened, maybe even pre-October. These kinds of cases, I was watching someone on YouTube, and I forgot the lady's name, but she was interviewed and a story was done about her with the New York Times, and I think she said it took like 9 months to get her story, to get it all sorted. And I had a subscriber on here before that worked at a much smaller newspaper and talked about how these things are months in the works. So even to think that October was the first time they heard of it and put together this huge story and this video, it's hard to imagine even just those months were enough to do what they made, to have all these conversations. So I don't know. A part of me really thinks that they were in contact before the Vanzan subpoena. I really do, and may have even suggested it or known about it. Hey, Docket Updates. I love your site. If you guys haven't been to docketupdates.com, make sure you check it out. It is such a cool website. They keep us updated on everything. They've got everything neatly organized, which I love to see when I'm trying to remember when something happened. And also Jesse from A-Hole Media has a really nice site too. Sometimes I'm like, I look at the way I've named things and I'm like, this was not done very well. And so I go to one of theirs to find what I'm looking for instead, because it's just easier. But okay, so that there's so many questions that as they start finding this out, did they receive anything before Vanzan? Did they know about Vanzan ahead of time? Were they approached with the texts and gave the instructions of how to legitimize them so that they could do a story about it? Who all spoke with the Times? Were Stephanie, Leslie, Ryan, Taylor Swift? Any of those parties, were any of them involved? How much of the story was written well in advance of the complaint, just based on the ill-gotten messages? What were they told about Vanzan? I mean, there are just endless questions to be answered about this. If those materials show that the New York Times knew or suspected the subpoena was illegitimate, again, actual malice, and like we've seen, possible fraud on the court. Now, reasons that they had, because it's all about, well, did they purposefully ignore these things? They saw that this subpoena was issued in a case with no judge, and it was a Doe case. Their legal team knew better. It was issued in a case with incongruent claims. So you had a Doe lawsuit with Vanzan, and it was about contract claims. I mean, that doesn't match. The claims don't match a Doe. You know who you have a contract with. How is it even possible to have a contract with someone you don't know? And then you have a subpoena that's talking about sexual harassment. It's incongruent. It doesn't go together. Something's wrong here. And you know that it's Blake Lively claiming that she's suing for sexual harassment to Justin Baldoni and Justin's production team and possibly the movie name. So why does it say Vanzan? What the heck is Vanzan? If someone brought that to me and they said, "Oh, I have this sexual harassment claim against, this movie, this guy in this movie," I'd be like, "Well, who the heck's Vanzan? You're going to have to explain this to me. And you're going to have to show me all the paperwork of what Vanzan is and what it has to do with all of this." If this was issued just to get Abel's phone contents, which is what it looks like, then the New York Times had obvious reasons to doubt its legitimacy. Under this U.S. Supreme Court case, well, both of these cases, St. Amant and Hart Hanks, publishing anyway, even though there's reason to doubt. And it's that, it's not like they can just say, well, I didn't have a reason to doubt it. It's what would a reasonable person think? And there's no shortage of us out here. There are tens of thousands of us out here saying to you, a reasonable person would know something's wrong here. The judge doesn't even have to sit there and wonder. All he's got to do is take a look across social media. Because we've all been saying, what the heck? For months. We were saying, what the heck, before we even knew that it was Vanzan. We just knew you're talking about a subpoena, but there's no lawsuit. And you won't tell us what the lawsuit was, and you won't say what the subpoena was for. And no member of Wayfarer was notified that there was a subpoena served. We knew something was wrong back then. No way they can say they didn't know better. All right. So how do you prove that they should have known that the subpoena was fake? Facially irregular. Courts treat obvious defects as red flags a reasonable journalist cannot ignore. It was not Megan Twohey's first day on the job. She was not without resources of a huge legal team. It was called Van Doe versus Doe's. And her claims, like I just said, I got ahead of myself there. No judge was assigned. The underlying claims in the lawsuit did not support what was asked for in the subpoena. The Doe complaint had no factual allegations. The subpoena was wildly overbroad. And the case was withdrawn 2 days before publication. These are all very good reasons that they should have known something was wrong. Now, and not to leave out Stephanie's attorneys accepted the subpoena. You think those attorneys didn't know something was wrong with that subpoena? So she and her legal team are in trouble too. They accepted that thing. They would, if they were worth their salt, they would have said, she's our client. We got her best interest at heart. We're not accepting this thing. They would have quashed it in a second. So she's under contract with Wayfarer. there's a mess with this employee. We can't do this. This subpoena is way too overbroad in the first place, and absolutely not. She's got an NDA with these people. They didn't. Why? They're in trouble too. Now, what else was wrong with that subpoena besides just the obvious stuff that we know? It was way overbroad. And when you're talking about third-party subpoenas, of course, not in Lyman's court, but yours, you have to very narrowly tailor those things. We saw the fights with them trying to get like Kate and Coslow's information, how much of a fight that was because they were third parties. It has to be a very narrow scope. And if you remember way, way back when we were all just babies in this case, when the first discovery was asked for, what Blake tried to do, because what she asked for all of this stuff on Jen Abel's phone going all the way back to 2022. And Wayfarer is like, no way. That's way too overbroad. And they're like, you got to narrow the scope in because you're just exactly this. There was a lack of particularity. You have to say very specifically what you want. You don't just get to access everything on somebody's phone. And Judge Lyman, what did he rule? He ruled that was way too far back. He did not grant her that. Even though he was granting her just about everything, he did draw a line there. He did not let her have that. And he also narrowed the scope. But this thing was just like anything and everything. It was like all documents concerning. Any attorney worth their salt knows that's way too overbroad for a subpoena, especially to a third party. And yet that subpoena repeated that over and over again. Everything about it was framed in fishing expedition. You can quash a subpoena based on that. Overly broad definitions, undue burden on a non-party. There were privacy, there were confidentiality issues. The temporal scope, like I said, back from 2022, that was way too overbroad. You can't just get years and years worth of stuff when you're talking about something that has a specific time frame. You know, your allegations all fall in this time frame. That's all you're allowed. And anything to do with Jennifer Abel was all just the retaliation. She had nothing to do with any of that other stuff. So her scope would have been even smaller in time frame than Wayfarer's would have been. So the compliance location and method, they asked for it to be brought to the office. It wasn't even an option to electronically file it. And they left it open-ended. Like, we can come back for more. Like, this isn't a once and done. Like, this is a continuing obligation. There's no way the court isn't even going to do that for the actual parties to the case usually, let alone a third party like this. So nothing about that subpoena was okay. And okay, Megan may not have known that, but her legal team sure would have. What else proves it? I told you we'd come back to this, and that's when you're relying on your only source being someone who has motive to lie. Like I said, Megan didn't see a juicy case at the courthouse and say, oh, I want to cover this. These people came to her. There is no way she knew any of this. I can say this with 100% surety because the CRD complaint is private, not public. So she would have had no access to that. Not only that, she'd started writing on this in October. These people came to her. So, and yet she relied on them as a source, even though they're a party in this case, and naturally they're going to give a one-sided report of things. They have motives to lie. They have this case coming up that they want to win. There's no way they're going to give the other side any grace. And lie she did. We saw that. She had to change her complaint to cover her lies. And if the source wasn't just Blake or wasn't Blake, it's one of these people because only so many people knew about the CRD complaint or that there was going to be a lawsuit filed. So it has to be from this very short list of people. Jonesworks, Blake's team, Leslie Sloan, or anyone involved in the PR war. Oh, thank you, thank you, thank you so much. All right, so quoting from these U.S. Supreme Court cases again, recklessness may be found where there are obvious reasons to doubt the veracity of the informant or the accuracy of his reports. So, is there an obvious reason to doubt? You better believe it. It's a party to a case coming up. Thank you, Justin Smotherman. We know from Taylor's text that was before Vanzan exactly. The great unsealing. Yep, we saw them being nasty, nasty, nasty. I don't even want to say mean girls because these are grown women. Blake's older. She's getting close to 40, for heaven's sake. Taylor's a couple years younger, but we saw their nasty messages. I almost said something I shouldn't say. They're not mean girls. And here is another U.S. Supreme Court case, and they say the evidence indicated that the publisher had in its possession information which would have caused doubts in the mind of a reasonably prudent editor or publisher as to the truth of the story. These are the things that you have to weigh when you're going to report. But this is why I'm not against free speech. I am not against freedom of the press. I'm saying nothing should be absolute. Everything should have limits, because when you don't have limits, this is what happens. People do whatever the heck they want, and they cause irreparable harm to others, and it shouldn't be allowed. We all have limits to what we can do, even within our freedoms. Like I said before, if you want to compare it to the freedom to bear arms, we all have that right. However, you can't, there's laws about felons. If you're a felon, you lose that. There's a limit. What else? There are places we can't take those weapons, even though we have the right to bear them. There are places you can't just walk around with them. There's limits. What else is there? There's limits to what kind of weapons you can have. You can't just go out and get just any old Russian AR rifle. There's limits to every right and freedom that we have. Why does New York say that they have absolute privilege for their press? It's not right. And it's caused this situation. It's like when you're driving down the street and you're late and you want to speed and you look around and there's no cop. And so what do? You speed. It's human nature. But when a cop's there, you're sure you're doing what you're supposed to do. Well, why is it so awful to ask that the press do what they're supposed to do? It is easier than ever to verify your story. Back when New York Times versus Sullivan happened, we're talking about the 60s. We're talking about there were no cell phones, there was no internet, there were no laptops. These people were out there walking around using payphones, taking pictures that had to be printed, and they were diligent. Now you don't even have to get out of bed. You can lay there in your bed and access the courthouse. You can access just about anything. These people had to go through phone books, and if it was outside their area, they had to call the operator and information, and there were these big series of green bound books if they wanted to look up people and businesses that weren't in their local area and find out who they had to contact. So they had to run down to the library and go through these books and try to find the person, and then either run back to the office or go to a payphone to try to call those people. There were no answering machines. They had to just keep calling till they got through. I mean, it was hard back then when that was passed, and they still did a good job. Nowadays, there's no excuse. You can do your best to do your job, and as long as you've done your best, I don't wanna see you get sued for honest mistakes. But if you're being this blatant, I'm sorry, you deserve punishment like everybody else. None of us have free rein at our jobs. We have rules we have to obey. Why does this one select group of people not have a limit? You can't even get your due process. You try to sue them, it will get dismissed before you get one piece of evidence to try to build your case, no matter what they did to you. That is wrong. That is not what the founding fathers had in mind when they said freedom of the press. That is not what the Supreme Court, who sat there and ruled on Sullivan, had in mind. We saw they were talking about government officials, and they were talking about their official conduct, not this. Something needs done about this. How else can we prove that the New York Times should have known? Number 4, they used the subpoena to bolster credibility. If they wrote that the documents were obtained via subpoena, that is a representation of legal legitimacy. If they did this knowing or recklessly disregarding, should have known that the subpoena was invalid, that is false, misleading, and evidence of actual malice. Courts treat misuse of legal process, because this is beyond that other stuff now. This is misuse of legal process, is a major red flag. Now you have frauded the court. I said the wrong word. How do you say that? Defraud. That's a word from 90 Day Fiance we used to laugh about, and it's popped into my head. Number 5, how to prove how they should have known. New York Times had time to investigate but didn't. We know that as early as October, they were writing this story. They didn't get it. Okay, so the CRD complaint was filed the day before, but that's not the first they heard of it. They didn't write it in less than 24 hours. They had time to investigate, but they didn't. And that's going to be proven with this discovery. They had months to verify the subpoena. And if they didn't, that is reckless disregard. What excuse do they have? Vanna, I love your comments. Yes, Ricardo, freedom of the press does not equal shielding from wrongdoing. Yes, Tina, when speaking becomes criminal, you are no longer free. Absolutely. Absolutely. The Supreme Court has repeatedly, and I've shown you 3 or 4 cases, held that failure to investigate in the face of suspicious circumstances is actual malice. That simple. So says the U.S. Supreme Court, and they are higher than you, Second Circuit, and they are higher than you, Southern District of New York. So when you put it all together, the subpoena was obviously invalid. I mean, we don't even have all the discovery yet, and we know it just based on what we've seen so far. The lawsuit was obviously a sham. We know it. The New York Times, now this part we don't know yet. Did they have it in hand? If they didn't, that's scarier than if they did. I don't know. Well, I don't know which is worse. They had the ability to verify it. If they're going to tout it on their article and say, hey, there's a subpoena, that's how we got access to this, you better have verified it. They have a huge legal department capable of spotting defects. Those defects are bright red. They relied on biased sources, and that's the truth. They ignored red flags. They published anyway, and they used the subpoena to bolster credibility. And they also used it to get out of this case. Now, here's my favorite part. Like I said, I would be so done with New York. I wouldn't even do the file the motion to try to revive it in New York. I mean, they might want to, and I won't think that they're stupid for doing it, but I don't think I would bother because I think they'll still find a way to shut it down. But here's what they can do. They can do a new lawsuit in California. And I would totally do that. California has much better laws about it. It doesn't have that absolute privilege that New York has. And that's where they suffered the harm. Get this out of New York. As far from New York, like coast to coast, as far from New York as you could possibly be. Now, there are some caveats to this. They can't just go and open a new defamation lawsuit in California. Now, if they do file their motion in New York and get that judgment set aside, they can start over new with that. But I'm only going to talk about this route, a new lawsuit in California. So because he dismissed that with prejudice, that's over. They can't come and file a new defamation lawsuit, even in California. But if it's based on new tortious acts that were not part of the original dismissed case, that's where everything falls different. So claims that could not have been brought earlier because the evidence didn't exist, because it was being concealed at the time. So that's that newly discovered evidence I talked about earlier. You can sue in California for new torts that were discovered later. This is where the sham subpoena evidence would become very powerful. If they can prove in the discovery that they engaged in separate wrongful conduct, things like fraud, that wasn't dismissed. That wasn't even brought to a court yet. That's a whole new lawsuit. And if this conduct was not known at the time of the original lawsuit, could not have been discovered, and it was being concealed. It constitutes an independent tort, then you can file a new lawsuit in California. And I really, really want this to happen so much. Where's this page? Sorry, guys. What did I do? Oh, I just got way ahead of myself. So at the time that it was dismissed, they were just finding out about this abusive process, if you remember. And it came out through a content creator and the Daily Mail. And that's how the world, including Wayfarer's legal team, found out about this. And the first thing he said is, this is an abusive process. Do you guys remember? So these claims, these aren't barred by that prior dismissal. They weren't part of that lawsuit, and they all were discovered after. It's newly discovered evidence, not available to them at the time. At the time, the New York Times and Blake were both saying in their filings that these documents were obtained via subpoena. But and they should have known the subpoena was invalid or relied on a subpoena that was part of a sham lawsuit, that's a separate tort from defamation, California recognizes abusive process even when the defendant did not issue the process. If they participated in or benefited from the misuse, they're part of it. Wouldn't that be amazing? So even if they did not say, "Hey, go get Vanzan," if they knew that it was a sham and they used it to report on, they're part of this abusive process, along with anybody else who was involved in it. This could bring Ryan back in. This could bring them all back in, depending on what they can uncover in this discovery. So I'm nervous about what's going to be allowed because of the weight of all this. Now, what else about California? That's good. I don't want to miss anything because this was like a lot of research and I'm getting a little sleepy now. All right, what else? Aiding and abetting tortious conduct. So they can't say defamation, but these are things they could possibly say, that they could possibly claim on a new lawsuit in California. Aiding and abetting tortious conduct. So how it fits: if the New York Times accepted documents that were obtained through the subpoena, they used the subpoena to bolster credibility. They published knowing or recklessly disregarding that the subpoena was invalid. They helped disseminate the fruits of the wrongful scheme. So that's the part they played. They didn't have to say, "Hey, go get Vanzan." They just had to know or recklessly disregard that something was wrong with that. But because they used it to legitimize their story, they would be involved in disseminating the fruits of the wrongful scheme. And that's aiding and abetting. And that is a tort in California. What else could they do? Civil conspiracy. That's pretty self-explanatory. Another tort: fraudulent misrepresentation or negligent misrepresentation. So fraudulent would be like more knowingly, and negligent more like should have known, but still misrepresented. Again, that comes down to them saying in their article and in their video that it was obtained via a subpoena. If that subpoena was invalid, part of a sham lawsuit, withdrawn before publication, facially defective, they should have known it was improper. And then they knowingly or should have known made a false statement. So that would put them in line for this tort. Then false light comes back. Now, false light was part of the claims that got dismissed. Now, normally when they get dismissed, you cannot bring them up again. This one, I'm not completely sure about, but I think maybe because he did not dismiss this for, like his reasoning for dismissing this was just that New York does not have this tort. So since California does, and it wasn't like this big old, well, you didn't prove false light. It wasn't something like that. It was like New York does not, we don't recognize false light. So it's possible, maybe, but I'm not sure about this one. It could come back on the table. And that's pretty close to defamation. So that would be nice to have that back in. If it's possible that they can get that back in there. And it all adds up, all of this together that we've been going through, and I know some of it's been repetitive. It all comes down to not defamation, because they cannot say defamation, but negligent news gathering, gross negligence. These are all new, but they're all serious. They're all torts in California that they could possibly and very, very hopefully pursue. And the last one, unfair business practices. This in California, this is extremely broad. And under the requirements of that, the New York Times conduct sure seems to qualify. Because if it's found that there was abuse of process, if they misused legal process, if they were fraudulent, misrepresenting the subpoena's legitimacy, this would all very easily stack up to this unfair business practices. So this is a pretty good list of possible torts. And remember, these are all ifs at this point. So I'm not saying this can for sure happen. I'm saying depending on how much discovery he actually allows them to get, if that discovery turns up what we think it's going to turn up, this is a very real possibility. Now, it's all tricky and it's all reliant on a lot of things like coming through just perfectly. Now, there are some little traps to avoid. We have this res judicata. What that means is judged matter in Latin. So that means this matter's already been settled. So we have this dismissed with prejudice. And this is the standard that stops you from being able to retry. So we have you've all probably heard double jeopardy. You've heard that more commonly than this one. Double jeopardy is in criminal cases. This is double jeopardy's cousin in civil cases. But it's the same principle that you can't have the same claims brought against you twice when it's already been adjudicated. So that's what that is. So that stops you from bringing the same claims again. So that's the reason they can't do defamation. So it can't be based on the same publication. It can't arise from the same nucleus of facts. And it can't be something that they could have litigated earlier and just failed to do. So you can't just bring up this second case with all new claims. It has to be something like, well, it can't be like, well, you missed it. You should have put this in your original claim. It has to legitimately be something that was not available to them when they began the first litigation. Vanzan was not available to them. So, and the stuff we're hoping that they get definitely was not available to them. So this is what they have to avoid, because if they wander into any of this territory, they can lose the case. They have to stay very, very far away from all of this. Even in California, they will lose it. They'll be like, well, you already tried this. Don't come here be tricky in California. So they have to make sure this is all legitimate. So how do you avoid it? The evidence did not exist in the record. They can't bring anything to the new lawsuit that they did have access to with the first case. So was the evidence concealed? That's what they got to stick to. And there is stuff that was definitely concealed. The discovery was stayed. They didn't get to do anything with the New York Times because as it goes in New York, he stayed the discovery before they handed over anything. And like I said in the last one, it could not have been litigated earlier. All right. So, and people were so frustrated with Brian Friedman and they just turn on him so quickly. And I hate to see it. They're like, well, why didn't he do this? Why didn't he do that? If you jump too soon, if you jump the gun before you have an adequate case, you lose your case. And we've seen that happen. We've seen that some of these things were scrambling because his house burned down when they were trying to put this together. If you come in too fast and you don't have all your ducks in a row, you lose it, and you lose it with prejudice, and it's gone forever. So yeah, we've been impatient for them to bring Vanzan into this. But the thing is, when they bring it in, they've got to do it right. They get one shot. So don't be impatient or feel like he's not doing his job. His hands are tied, and this judge hates him. He really hates him. And by extension, he's not nice to the rest of the Wayfarer lawyers. So they got to be very cautious how they move, and they've got to make sure that they have everything perfect, or he's going to happily slap it down. So there's landmines all around them for how they've got to proceed. And that's why I would love to see them back in California and get this. Like, if you know of anyone that's ever going to try to sue any kind of press in New York, tell them don't do it in New York. Find some way to Do it somewhere else, because once you're there, you are at their mercy. Now, and here's the thing, I don't, subscribe to the New York Times. I will never subscribe to them after this. Um, if they have updated the article since the motion to dismiss, now I know they updated it after the original one, but I think they did it really soon after. But if they have updated that article after the motion to dismiss, so if anybody knows those things like docket updates, or any of you who like watch all of these little details, tell Wayfarer. Seriously. Because if they have updated since the motion to dismiss, that opens them back up to defamation again. If they, since the motion to dismiss, tweeted about it to like advertise it again, that opens it back up. If they've pushed it in newsletters, if they've promoted it again, since it has to be since the motion to dismiss. But all of you eagle-eyed people out there, if you know for a fact they've done that, and if you have proof that they've done that, Wayfarer needs that, because that will open them back up to the defamation claim. They won't have to just focus on these other torts. They can go for defamation again. All right, this is the Rule 60B motion that I was talking about. It's asking the court for relief from judgment. It's basically saying take it back. The dismissal of the case. So if they can, through this discovery, if they can get this newly discovered evidence I talked to you about that couldn't have been found earlier because they didn't get access to the New York Times, they can ask him to reopen this, to pretty much take back the that with prejudice ruling. If they can prove that there was fraud and misrepresentation and misconduct. If they can prove that there was fraud on the court. Did you come here before the court knowing that the subpoena that you talked about that protected you to write this article, if you knew it was fraudulent and you told the court this? That's another reason. A fundamental procedural defect, a void judgment, or extraordinary circumstances. So these are all things that you can file this Rule 60B motion. It is very hard to get. The standard is very, very high. You have to have tons and tons of proof. You have to present it just so. That's why I say I don't know that I would even bother. They may, because that would reopen it back in New York. But if they could at all do it in California, I would skip this one altogether. But anyway, that was a long one. Sorry, guys. I kind of knew it was going to go long just by the number of pages I have here. But I'm so sorry that I started late. Thank you guys for standing by and waiting for me. But it's and I want to repeat again that I'm not saying this, any of this is what's going to happen. I'm saying this could possibly, and I'm very, very hopeful that this is what will come of all this. And yeah, so just there might be some oxygen being breathed back into some of this stuff, and it would be so amazing to see. But anyway, so we can round out the 2 hours if you guys have some questions or things you want to say, because I was mostly ignoring the chat again. I kind of have to. How many vacuums has your husband bought from the salesman that caught you right before you started? You talking about Omar? None so far. Yes, we gotta love Steve for not getting scared off the case and for being the reason that they can continue to take it this far. You know, I'm just so happy for him, because if not for him, and they hate him so much for it. All the times they have bitterly mentioned that billionaire, and this last, the one where they were like, They literally counted the number of attorneys and law firms. Did you guys see that? Like, they're such babies. They're talking about all these prestigious attorneys that they have. They are so jealous that they're backed by a billionaire and have a bunch of attorneys that they have mentioned these 2 things so many times. It's like, what are you guys in middle school? Seriously? Oh, sorry, getting sleepy. I was up really late last night making this. Me too. Me too, Gia. The opportunity for justice has me hinged. Me too. I am so excited. I got so pumped when I read this. I really did. Like, my emotions were such a roller coaster. I was in Greece, but I would, like when I couldn't sleep or had some downtime, I would like take a look to see what was going on, because it always happens like when I'm not available. That's when big stuff hits the docket. So I was trying to read it, and the first few, and he's like granting, and I was getting so mad, and I'm like, he's just gonna what's it's because I knew he said denied in part, granted in part, and I'm like, but these are all being denied, like, what's he gonna grant? And then I got so excited when I saw that he left the defamation claim in. And then I got worried. I'm like, it's still not gonna cut it. And then I started researching, and I'm like, there's hope. So it's gonna be like that, I think, because they're still they're still at the mercy of the court for how much discovery they get, like what he allows. And historically, New York protects the New York Times. So we'll see. Fruit of the poisonous tree, same as fruit of the poisonous scheme. Um, it's kind of related. Now, the actual fruit of the poisonous tree is more so like a criminal case thing. It's not such a big thing in civil cases. Even if it's found to be, like, ill-gotten, a lot of courts in civil court will still, like, in criminal court, that's it. It's done. You can't touch it. You can't touch any of it. In civil court, it's a little different. They do make allowances on that. Um, but yeah, this poisonous scheme, I think, was more like in like the whole conspiracy fraud that was put on everyone. But it's kind of like if you contributed in any part to disseminating the fruit of that poisonous scheme, you're involved. So not really the same thing. No. Yeah, the poisonous scheme is like the whole the whole bad faith way of it all from beginning to end, and any part you played in it, you played a part in the ultimate how this fruit was disseminated. Anybody who played a role in getting this defamation out there. The final defamation was the New York Times article, but everybody who contributed to that is part of that poisonous scheme. You've fallen asleep to my voice. It's getting kind of I hate when it starts to get like tired and kind of what do they call that? Like fry, something like that. I feel like it's going to start doing that because I'm sleepy. So I'll probably call it a night here. And thank you guys so much. Thank you so much, CM. I always want to say CM baby because just I see the BBY together. For gifting 5 memberships. And thank you, Ricardo, for being a member for 4 months and for the $2. Thank you, Justin, for the $5, and Gelf. And I hope you feel better. I hope you don't have a super long wait in the ER. And thank you again for more memberships. And Justin Smotherman, again, for the $2. And thank you all so much for your wonderful comments. Thank you, Christina. And I hope this gives you all some hope, and I hope our hopes don't get dashed. That's a lot of hope. Anyway, thank you guys so much. Have a wonderful rest of your evening, and I will see you soon. I will see you in April.